Hi, I'm Saren Coach with Alt Legal, and I'm here today with Jeanne Fromer, an NYU professor of law, also the co-director of the Engelberg Center of Innovation, Law, and Policy. I'm here with Jeanne today to talk about fake specimens. She, along with Barton Beebe, another NYU professor of law, wrote an article about fake specimens, and we're here to ask her some questions. So, Jeanne, first question, why did you decide to write on this topic? And can you give me some background on how you discovered the issue of fake specimens being filed?
Yeah, sure. And thanks for having me here. So, as some background, my co author and NYU colleague Barton Beebe and I had spent the past few years studying US trademark applications and registrations from an empirical perspective in a different context, whether we're running out of trademarks. And we concluded in brief we are. But that's another story we'll come back to soon. It all connects. But we'd gotten into and some knowledge about the topic of fake trademark specimens because we saw and heard from practicing lawyers. We heard from practicing lawyers noticing this issue that were in-house counsel like Stephen Lee at Target, which is the biggest trademark filer in the US. And we were hearing this from counsel at law firms like Josh Gerben. And these folks had been noticing a tremendous increase in filings at the US Trademark Office from China. So just to give a sense, as of 2017, there was a tremendous increase in these filings. They came to represent 10.5% of PTO, Patent and Trademark Office trademark applications. And if you think that's high, it crept up more and more. Just this past November, they represented 35% of all US trademark filings. They were coming from China. So there was this huge increase and people were trying to understand what's going on. Obviously, there's been a lot more Chinese business operating in the US, but people were suspicious that it didn't seem to add up. It was a very high number. And on top of that, what trademark lawyers were noticing was there were suspicious things in some of the specimens that had to be filed as part of the application to indicate that the mark was being used in American commerce as it needs to be to get a registration. And because of that, companies like Target, they'd done some investigations and try to track down who was using certain marks, and they couldn't find anyone behind the application or the registration. And so it became clear there was a problem. Barton and I worked with Congress on what ultimately became the Trademark Modernization Act. And I'd been asked to testify in the House committee hearing. Barton had been asked to testify in the Senate committee hearing. And what we realized in participating in the discussion there was clearly a problem with fraudulent trademark specimens, but no one had quantified the extent of it. And so we wanted to set out to get a sense of how bad the problem was.
Great. So then how did you go about researching this topic and what did you discover?
So first we explored the specimens from China just, on our own to get a feel for them, which in recent years, and not just from China, all specimens are on file publicly with the US Patent and Trademark Office online. And there were many that looked suspicious and fake to us. And so we decided to go through them systematically. And what we did was we randomly sampled 365 applications from the 6,752 use-based applications that had originated in China and were filed in the Trademark Office in the US in 2017, solely in Class 25 for apparel goods. And that was to get a representative sense that we would be able to statistically make conclusions from that. That's why we picked that number. And so we coded all of these applications for multiple factors that we thought indicated fraudulence. So one example is, were there discontinuities in the digital image that indicated a digital alteration? To give a sense of the other factors that we looked at, we checked if it appeared in a Google reverse image search that would match an image of a product that had a different mark of a different company, or that the specimen image matched specimens that had previously been submitted to the Trademark Office and other applications for different businesses. Another factor, for example, is that it depicted a mark that consisted of a nonsense word that is totally unpronounceable in English, and the applicant did not indicate it had any meaning in another language. There were irregularities on the tags. It depicted pricing in a foreign currency rather than a US currency, because remember that trademark law in the US requires that it be used in US commerce. So depicting it being with a foreign pricing suggests that it's not being sold in the US, or at least that specimen doesn't indicate that. Sometimes, we would even see that a product would carry the mark of another company. So it would have their own tag, but it would also say something like Chanel on it too. Or that they even misspelled their own mark, which suggested something fishy was going on. And on top of that, there were other factors such as did not have a tag attached. Did just have a card placed on top of it and whatnot. So we coded for all of these factors, and then we took into account a subset of factors that we thought were especially indicative of fraud. So we try to be on the more conservative side here, and based on that, we estimated that 66.9% of Chinese use-based applications filed in 2017 solely in class 25 included fraudulent specimens. That was a much higher number than we had expected to find. And, many of this is 244 applications that, got flagged then as being fraudulent. And many of them had multiple flags. It wasn't just that they hit like one of the flags, right, that there were digital alterations, but they also misspelled the mark, or they also didn't have a tag attached. And the really astounding thing to us is that even though the Trademark Office was catching some of these, 59.8% of these applications proceeded to be published, and then 38.9% of them proceeded to register. So that's, a lot still getting through. And, then we calculated this. If class 25 applications are representative of the overall population of Chinese origin applications in that year, then approximately 28,585 applications were fraudulent that year. And that represents 14% of use-based applications filed in the US Trademark Office in 2017. So we walked away from this thinking, wow, this was a much higher number than we expected, assuming our findings were representative of the overall filings.
Absolutely. So basically, the next question is, why are so many of the applications with fake specimens originating in China? And why are so many of the fake specimens being filed for goods in class 25?
Yeah, these are great questions. And, we try to understand what's going on here. Why would anyone want to do this, right? What's the upside here? And, what we found both through press reports and from reports from people on the ground in China is that there are certain regions in China that are offering incentives to their citizens to secure US trademark registrations. Okay, so why would they want to do that? As far as we can understand, it's likely to be a signal to central government that this is a region where there's lots of commerce, lots of innovation going on, because look, here are all these US trademark registrations that have been secured. And so it makes them look good. Now, I have no doubt that these regional governments are actually trying to encourage business, but the amount of money that they're giving as an incentive is more than it costs to file a single class trademark application, assuming it goes through smoothly. And in that case, it's a real incentive to people that are in these regions to throw together a fraudulent application. It obviously is also an incentive for legitimate businesses, but it creates this incentive. And so I think that's the best explanation, I think, of what we're seeing in terms of this taking off. And in fact, the filings do coincide with the regions where we know these incentives are being offered. Now, why class 25? What's going on here? And why did we study class 25? Well, Class 25 is apparel goods. And what we were noticing in the pictures, and this is not something we could say as a matter of being objective, but this was just our sense of this. It looked like people had taken things out of their closets and photograph them and put a tag on them or altered them, or it's just so there are some classes that have typical household items, clothing. We were noticing the same thing, by the way, for silverware. It looked like people were taking silverware out of their drawers and photographing it, and also filing for registration. So I think it was so this is the long story short, is that maybe what we're seeing in class 25 is more extreme than we might see in areas where it's more expensive to get access to the goods or at issue there, and pull this off, and that very well may be. But there were other classes where we were seeing very much the same thing.
Got it. So our next question is a couple questions in one, but why is this such a serious issue for business owners, particularly small business owners? And then if we could talk about what is trademark depletion and clutter? And then finally, what is the cost of these issues?
So let me take a step back and first start by explaining trademark depletion and trademark clutter, because I think once we have a sense of what those are, it gives a sense of why this is such a serious issue. So trademark depletion is something that Barton and I had been studying in earlier work. That's what we refer to as the decreasing supply of unclaimed, competitively effective trademarks that are available to new market entrants. And what we've been finding is that there are increasing rates of trademark depletion over time, meaning that there are fewer and fewer competitively effective marks that are available to new entrants as time goes on. Marks are getting longer. They are getting less desirable in the sense that, let's say, commonly used English words or surnames, they've been so claimed that it's harder and harder to find one without having to make up a word or choose an undesirable existing word as a mark. And it's harder even to find marks that are not confusingly similar with these marks, as we're also seeing increasing rates for confusing similarity. Okay, so that's trademark depletion. And we've also got what seems to be, particularly from a study like this, increasing trademark clutter. Clutter refers to marks that are registered but are not actually used in commerce. Now, American trademark law requires that marks be used in commerce. Not all countries do that, but the US does. And the problem is that as new businesses come on the scene, or existing businesses want to create new products and they need a new mark for that, it's becoming harder and harder for them to find these marks and to sort through this clutter that's on the trademark register and picking out these marks. Meaning that they try to find something that's available. There are fewer and fewer things available. Now, some of these things should be available to them because to the extent that they represent clutter, they're not legitimate marks because they don't comply with the American trademark law. But it's really hard to figure that out from looking at the trademark register. What ideally we want is that if something's on that trademark register, we know it's been used in commerce. The trademark examiner certified that, and the Patent and Trademark Office stands behind that. And a business knows, it looks at this and knows it's being used in commerce, and then it won't use the same or confusingly similar mark for its similar good or service. Okay. Now, this is hard on legitimate businesses because there are just fewer marks available for them to register, or they have to spend lots of resources to do detective work to figure out if a mark's actually being used in commerce and whether they should fight it and use that mark. This is really hard on small businesses because that's really costly for them. I mean, they don't want to have to be spending all or a significant portion of their resources on this. They want to spend it on their business. And so I think this has become a real problem as we're seeing the combination of increasing rates of trademark depletion plus clutter, in the sense that you don't even know what to trust on the register. You just assume everything is off limits on the register, or might some things be actually available for use ultimately because they're not actually being used. So that's why I think trademark depletion and trademark clutter both cause problems for legitimate businesses, particularly small ones.
Absolutely. So the next question is, how can a trademark examiner discern a fraudulent specimen from a digitally altered image?
Yeah, I think, when, the work that Barton and I did actually gave us a really good handle on what the examiners could be doing, because all of the factors we were looking for and coding for are things that trademark examiners can do themselves. It's anyone can take an image that they get digitally and plug it into the Google's reverse image search and see if there's anything else out there with a different mark on it or being offered by a different company. You can visibly detect a lot of these digital alterations. You can look for these misspellings or foreign commerce. So all of these things are visually discernible. On top of that, there are ways to systematically build up to make it easier to detect fraudulent filings. And I think, I give the Trademark Office credit on this because they have been moving in this direction to really do a better job over time of detecting these fraudulent trademarks. So, for example, they could build up databases of submitted specimens the same way you could search Google against all images out there. It would be great to be able to search all the specimens to see if the specimen has been submitted beforehand. We'd find the same pair of blue leggings submitted again and again and again, or strangely patterned leggings. You'd think someone would want to pick something very that wasn't memorable, right? That you would remember, but we'd find these strange patterns on clothing repeated again and again. And so you knew something was up. And so if examiners can search, particularly in an automated way, against previously submitted specimens, I think that's very helpful. And I understand, and I think, they're moving in this direction, is to be using artificial intelligence to not have to detect every single alteration visibly, but to have the guidance of technology to be able to detect where if there have been alterations in the image. The last thing I'll add is something that is on my wish list for Trademark Office to do, which is specialized examination. I think that right now the Trademark Office is structured in a way where each trademark examiner gets a random sample of all the applications and all the classes of goods and services. It didn't used to be that way until the 1990s. They were specialized by industry or by class of goods and services, which meant they came to know the classes and repeated applications in those classes for the particular sectors that they covered, such as beverages, right? Then they knew things. The examiner knew a lot about beverages. Now that expertise is lost. And I think if there were to be specialized examination, I think it would have a host of benefits, but including on this front, because if you're doing Class 25 apparel, you're more likely to see the repeated filings that look fraudulent, or to know what to look for, what looks off with regard to clothing, which might be different than what looks off with regard to beverages or machinery. And so that's one way to specialize. Specializing could also be by region in theory. And so there have been calls to appoint specialized trademark examiners to deal with all the applications coming in from China. There have been such a crush of them that I think it's probably been overwhelming for the Trademark Office. So I'd love to see specialized examination. It's on my wish list, but they are doing a lot of other things, I think, to try to detect these fraudulent specimens.
Well, that is great news. The next question is, what do you recommend to prevent fake specimens from being filed?
Yeah, so here is I think in addition to what we've been talking about the having the Trademark Office do a better job with this, I think there are things, procedures that can be put into place to do a better job of this, and in particular, two procedures that Congress has put forward, which are ex parte reexamination and expungement. And what these are two new expedited, ostensibly cheaper procedures to cancel trademark registrations for marks that have not been used. Ex parte expungement is for marks that were never used in commerce, and ex parte reexamination is for marks that were not used before the relevant use date in registration. So that's when they said they used the mark, but they didn't. And these are procedures that can be initiated by third parties and also by the Patent and Trademark Office of its own initiatives. And in addition, Congress is also allowing third parties to submit evidence during examination of a trademark application, including that the specimens were doctored. And the reason these are important is because the existing procedures to cull marks that are not being used from the register, in the way that we were talking about, right? A business does detective work and finds a mark's not being used. What can it do? They're really insufficient. And so the primary procedures are opposition and cancellation. And opposition has a very short time period to use it. A third party can oppose an applicant's mark, and there's a very short time window. So if that time window closes, that's unavailable. So that's not great unless you catch it in the nick of time. Cancellation is the other procedure, but cancellation is not great either because there are very limited grounds on which you can cancel or apply to cancel a mark after 5 years. But really, I think the biggest limitation, and this is true of opposition as well, is the high cost. And that can be burdensome particularly to smaller businesses. There's one study out there that the average cost of a trademark opposition in the US ranges from $150,000 to $500,000. Another estimate puts the median cost of a US opposition or cancellation proceeding to be $95,000. So that's not spare change. And so that's expensive. And so to have a more streamlined procedure to deal with marks that have not been used in commerce and submit this documentary evidence showing that a mark is fake, hopefully that will provide a cheaper and faster mechanism for businesses to help cull these marks that are not being used, particularly because they have fraudulent specimens that were submitted, indicating that they're not being used. And it also provides the PTO a way to go back and look through systematically. Let's say it comes up with new technology where it could detect fraudulent specimens. They can go back and look for the ones that are on the register that they weren't able to detect as easily beforehand and actually file to re-examine or expunge those marks themselves because they have that power too under these new procedures. So, I think those are going to be helpful in addition to the work that the Trademark Office is doing on its own to help prevent these fake specimens from sitting on the register for too long.
Absolutely. So Jeanne, the final question we have for today is what is currently happening in the House, Senate, and the USPTO to combat the issue of fake specimens?
Well, that's a very timely question because in December 2020, Congress actually passed the Trademark Modernization Act in the coronavirus stimulation bill. So there was a huge bill, and this was part of it. And so this bill that had been working through Congress for a while actually just passed, and it includes these new expedited procedures for reexamination and expungement. And so I think that's the huge news of what's been going on in the House and Senate. So a lot of hard work there, and that's paid off with Congress passing that. The Patent and Trademark Office, as I'd said, is working on improving its technology to detect fraudulent specimens and applications, and also has been issuing updated examination guidelines for its examiners and for others who are filing to be on the lookout to help detect these marks. I really hope this will be a priority of the Biden administration going forward. As we see from the numbers, the Chinese applications are skyrocketing, and it's really important to sort out applications that are for marks being used legitimately, which I have no doubt there exist from China and elsewhere, and the ones that are not, and to really ensure the integrity of the register. So I think things are moving in a good direction, and I hope it will continue to be a priority.
Great. All right, well, that's all I have for today. I want to thank you so much for joining us. We really appreciate all of this wonderful, helpful, and informative information. For anybody who would like to read more about fake specimens, I'm going to be posting a link to Jeanne and Barton's article along with this video. Thank you all so much.